Welcome to the webinar, The Critical Role of a DPO, Why Outsourcing is Smart Choice. This is a webinar that is organized with GRCI law and ITG governance. Basically, we have the honor to contribute to the Data Privacy Day. The 28th of January is the anniversary of the Convention 108 that has been signed on 28th of January 1981, and this is our contribution to reinforce awareness on data privacy rights. I have the honor to be joined by Natalie Best, a very well-known expert in data privacy field. And so we will go on moderate this webinar together today. And let's start with some introduction of ourselves, the speakers, and also of our company, so that you are aware on what services we can offer to you. My name is Loredana Tassone. I'm a qualified lawyer and trainer with more than 15 years experience in the privacy field. I have been qualified in France and in Italy and worked in several jurisdictions in the EU and also got experience in the common law system. I have been servicing the Registry of the European Court of Human Rights for several years, as well as the Council of Europe, and worked in international law firms in the data privacy and cybersecurity field, and also completed a PhD on data processing activities within the judicial system, and cooperated with several universities such as Manchester, Salford, and Strasbourg. I currently sit in GRCI law as a managing consultant, head of EU and UK representative services. Natalie, could you please introduce yourself?
Hello, everybody, and welcome to our webinar today. And I hope you enjoy your International Privacy Day. It's a very exciting day for privacy, really. So my name is Natalie Best. I was previously Natalie Whitney, as you can see there, if you don't want to confuse you. But I'm a member of the senior management team at GRCI Law, and I'm head of legal contract and legal services. So I've started many years ago. I don't like to tell my age, but several years ago, over 20 in any case, working in commercial contracts for GRCI matters, and I worked on international high value contracts at the time. And I've spent several years doing that, but in African countries, Australia, New Zealand, US, Europe, and within that time working on commercial contracts, obviously risk management became a large part, and compliance. And I developed an interest in data protection quite a few years ago. I've worked with large companies like General Motors, Vodafone, BT Global Operations, National Air Traffic Control, Network Rail. I've also worked for the Department of Justice and SAMEX and the Department of Transport. And I've negotiated various contracts with African countries and for rail purposes as well, and in various values from 20 pounds or euros right up to several hundred million. But in that interest, I've really decided a few years ago to specialize in privacy, and I've been working for GRCI Law since we started in privacy. And I really enjoy working there and dealing with all the different privacy issues that clients have. So I'm very boring. Don't invite me out, because I'll probably, unless you really enjoy privacy, because that seems to be all I talk about. so I'm told.
Thank you, Natalie. So some introduction for our company. So we both, Natalie and I, are part of GRCI Law, which is a legal risk and compliance consultancy firm. It is not a traditional law firm, so we are not undertaking contentious activities or undermitted to the regulator. We are a team of lawyers and DPO that have legal background, so we have a long-lasting expertise in the data privacy and cybersecurity field, and we operate in conjunction with IT Governance, which is our sister company. Both GRCI Law and IT Governance governance are subsidiaries of GRCI International Group. IT governance complement us with services that are of interest when you try to get a good level of compliance, as they offer quite large range of products on cybersecurity, certification, audits, and also tools like CyberComply that are very helpful to ensure that a good compliance level can be achieved. Services that we provide are like conducting GDPR or other data privacy law gap analysis, privacy audits. We offer the outsourced DPO service, data breach support, a larger service called privacy as a service, and also we can support with legal and contractual matters, and also basically provide toolkit and templates. So really, we are like to use a terminology that we have in the privacy arena, like a one-stop shop where you can obtain the tailored service that you need in order to reinforce your compliance. So we are well known, and figures can show how we have been supporting business through the years. Our company is existing since quite a while before the GDPR has entered into force. So Natalie, would you like to show us some figures on how we operate?
Thanks, Loredana. Yes, we've been around, I believe, since the first cybersecurity textbook that I previous year Helen wrote, and that was quite a number of years ago. I can't give the exact time, but we have quite a history and we've been growing since. So we've worked, as you can see on this, with over 1,300 projects to help organizations prepare and maintain the ISO 27001 compliance. We've got more than, we've trained more than 15,000 delegates in privacy and cybersecurity, and issued over 7,000 cyber essential certificates, and more than 2,350 customers use our governance risk and compliance software. So we do a number of projects, and because, as Loredana said, that we're a one-stop shop, there's really quite large projects with various elements, from data transfers to checking on cybersecurity and getting certifications for businesses, trying to ensure that their privacy and security aspects of data protection are aligned. We can do all of it. So there's someone in the company that can do it. So it's really useful for any of our clients if they have any projects. And of course, we're quite experienced in multinational large projects as well, with various elements regarding to privacy and cybersecurity. So I really enjoy working with us in this expertise area because there's such a variety of things that we actually do. Thanks, Loredana.
Thank you, Natalie. So before to go through the substance of the webinar, just a few reminders on housekeeping. So all the participants will be muted during the session. However, there is a facility for you to raise question in the chat, and we have a specific session on questions at the end of the webinar, where we will try to address the questions you will raise during the webinar. And if we do not manage to do so, we will contact afterwards to respond to your questions. And also be reassured you will receive the slides and the recording, so no please do not bother in taking notes, as you will have all the necessary material afterwards. So in terms of the content of the webinar, previous slide, please. So we will gonna cover the requirement for a DPO, mainly Article 37 to 39 of the GDPR, the key role and responsibility of a DPO, and we will focus on independence and absence of conflict of interest, which are two essential requirements for the DPO to be able to basically fulfill his role and task in line with the GDPR. And we will go through some cases that have been brought to our attention, and we will also cover the benefits of outsourcing the DPO, and also how GRCI law can help in outsourcing the DPO and maintaining a good level of compliance. In terms of the DPO requirements, we have the GDPR that basically is driving us on requirements. So when we have to appoint a data protection officer, when this is a mandatory requirement, and also we do have the rules in regards to the role and the position of the DPO that are set in the GDPR. So, according to the GDPR, controller and processors must designate a DPO in three situations: when the processor or controller are a public body, so in whichever case the nature of the public body will attract the necessity to appoint a data protection officer. The other situation is when core activities are basically requiring regular and systematic monitoring of data subject on large scale. And the third situation is when core activities involve large-scale processing of special categories of data or personal data relating to criminal conviction and offenses. The GDPR doesn't clarify what core activities are, or doesn't define monitoring activities, systematic monitoring of data subject, or the notion of large scale. After the GDPR entered into force, several guidance have been produced at the European level and also from the supervisory authority at the national level. So we have, of course, elements in order for us to define what those notions means. So the core activities are basically the activities a business conduct for the scope of its business. So, for example, a company that operate in the health sector that conduct clinical trial, core activities will means that basically are activities related to the clinical trials. In practice, companies in general, they will have two pillars of that processing activities: the processing activities that are necessary for the organization to function. So basically processing activities related to finance, human resources, marketing activities related to the activities of the business, and the core activities will be the data processing activities that are necessary in order to conduct the activities that are in scope of the business itself, as said, for example, the case of business that work on the clinical, on the health sector, and therefore they conduct clinical study, for example. And in terms of large scale, we have received indication on the fact that it is necessary to take into consideration the number of data subjects that are concerned, the geographical area where the company is operating, and also the volume of data that the company is basically processing. We can assess, therefore, considering the guidance, if we are in the situation where we need or not to appoint in a mandatory manner the data protection officer by following the available guidance. Next slide. So the GDPR also clarified that a group of undertakings can appoint a single data protection officer. For example, in France, we know the Délégué à la protection des données mutualisées. So a group of undertaking can have the same DPO. And where the controller is a public authority, also there is the possibility for a single DPO to be appointed for several of such authority, depending on the structure and the size. Of course, it needs to be guaranteed that the DPO appointed this way can cover all the tasks that are requested under the legislation. A DPO can also represent a categories of controller and processor, and needs to be appointed based on professional qualities and knowledge of data protection law. The GDPR doesn't explicitly require for the DPO to have a legal qualification, However, it says that he needs to have an appropriate expertise comparing to the processing activities of the company, need to be able to understand the law, data protection law, and also from our experience, we know, so we have case law from the European Court of Justice, decision from tribunals, or decision from the supervisory authority. So it's necessary to assess and be able to understand the impact of complex decisions and how the business need to impact that in policies, procedures, and practices. So also it is not a requirement to be legally qualified for some business that have complex processing activities and do have to deal with, for example, international data transfer, or need to understand the interplay between the GDPR and other piece of legislation like the medical device or clinical trial regulation or marketing specific legislation. It's highly recommended that the DPO has at least a legal background, if not a qualification even. So the DPO may also be outsourced, so it can fulfill its task and role as a part of a service contract with an individual or a company like us. And controller and processors that have appointed officially a DPO need to provide information on the contact details of the DPO, and of course notify the supervisory authority according to the specific procedures that each supervisory authority has at the national level. This doesn't imply that privacy notice need to have the name and surname of the data protection officer, but it needs to include a general email that is accessible from the data subject and also from the authority, and also a postal address. This has been also required in terms of notification of EU and UK representative services. So the same level of information needs to be included in the privacy notice as part of transparency and accessibility. So we have a situation where the DPO needs to be appointed in a mandatory manner, and also situation where the business processor or controller may decide in any case, even if you are not touched by the obligation, to appoint a data protection officer in a voluntary manner. The voluntary DPO and mandatory DPO will be submitted to the same level of rules under the GDPR, so they will need to abide to the same requirement and fulfill the same task, also if they are appointed in a voluntary manner. And if a company needs to have someone that is specialized in privacy, but they do not want to appoint officially as a DPO, this individual, this professional cannot be called data protection officer. It can be a data protection manager, but or another title, job title, but cannot be identified as the data protection officer. Can we change slide?
Can I just point out something I've just thought about how useful it is for any of you who are listening to the webinar on multinationals? Rodon has mentioned that even though it's not necessary that someone have a legal background, it's really useful for multinationals who have to look at GDPR and how it works along with other legislation, like the California CPRA or Serbia's legislation or various privacy legislation around the world, because it's really useful if you can read that legislation, understand it, compare it to the GDPR, and be able to actually make sure that your privacy notices or any other documents comply with all those regulations simultaneously. Sorry, Loredana, I just wanted to point that out.
Very good point, Natalie. Thank you. So in terms of the position of the DPO in the organization, so the controller and processor must ensure that the DPO is involved timely in the data processing activities and projects, so that is aware of projects that involve processing activities, so that he can advise and give recommendation and take care of the compliance aspect around the project. controller and processor must ensure that they have allocated enough resources. This is financial resources or human resources. So some companies, if they are a large company and they have large scale processing activities, they may need to have a team rather than one individual covering the DPO task. So it is necessary for the compliance project to have a number of employees that work on it that is proportionate to the level of activities that the role would imply. The DPO has also to have a large degree of independence because his role is advisory and need to provide guidance. And we need also to bear in mind that the DPO role is to ensure that the company will entrust GDPR and the data privacy rules, and the protection of the data subject rights are protected in an effective manner. So there may be situation where a project may entail risk for the data subject, and the DPO would give advice that is not favorable to the project, and needs to be in the freedom to do that. Then, of course, the ultimate decision stays with the processor and the controller, so they can override the advice of the DPO as far as they motivate it. But still, the DPO needs to be able to fulfill his role in complete independence. And in conjunction with that, the role of the DPO is also a protected role within the organization, meaning that it needs to be made sure that the DPO is not affected by disciplinary procedures or dismissed because of the compliance with the legislation and fulfillment of the role as described in the legislation. He has to have direct access to the management so that he can inform and advise. This typically is made through participation or submission of reports to the board in regards to the status of compliance and main risk and guidance and recommendations that apply to the specific situation. Data subject needs to have access to the DPO. As said, there must be communication in the privacy notice, but also and it need to be ensured that the DPO can be reached by the data subject, and also it is bound by confidentiality according to the EU law. Next slide. So in terms of the hierarchy in the organization, so the DPO generally will sit in the compliance and risk team, and it is necessary to ensure that the DPO has a correspondent, or in any case has access to the department of the business, human resources, IT, information security, quality management, so that he is aware, as said, of project or anything that change in terms of how the data processing activity are handled. If, for example, there is a need to change the service provider for the payroll or anything that it relates to data processing and risk associated to that, the DPO needs to be aware so that he can be able to give his own advice and guide the management on risk associated to the changes. So it has to be independent from the business, has to have access to the board, and has also to ensure that the data protection topic is regularly in the agenda of the board, so that it is a topic of discussion. What are the DPO role and key responsibility then? So the DPO role is to inform and advise on privacy obligation, monitor compliance with the privacy obligation. So if the company has a set of procedures and policies, the DPO need to ensure that those are in line with the obligation and also that are effectively applied by the various departments. It needs to provide advice on data protection impact assessment, needs to monitor monitor the performance, so as to say to see that the practices are in line with the policies and procedures that the company has adopted on the field, and then needs also to be able to cooperate with the supervisory authority if there is an audit, if there is a complaint. So it has to be able to communicate with the supervisory authority and liaise also with the data subject in case of data subject rights requests or queries that may come from the data subject, and also has to have due regard to risks that are associated with the processing activities. So every action that the DPO will take will need to be based on risk assessment, and there are, for example, when we conduct that protection impact assessment, some area that may be on a low risk or a high risk. The fact that there are activities that are under low risk doesn't mean that they need to be disregarded. They are not placed as a priority, so all risk needs to be considered and the appropriate measure needs to be taken, and the DPO need to be able to advise on that. The DPO also has to be able to understand the compliance problem. This implies that the DPO has a good understanding of the structure of the company, owners and the shareholders, who they are, senior management, how the structure function, and also the place of customer, and also needs to be able to understand the legislation and specific regulation that may apply depending on the specific field of the company. This is covered. Next slide. So in terms of informing, the data protection officer will need in some instance to manage awareness campaign for staff or conduct training for the staff. And also highlight risk and issues to the management. You need to be able to advise to stakeholders, and it is good practice to have the advice and decisions that are made around compliance recorded. And so, for example, if there are meetings or specific discussion around a specific project, always follow up with a summary and email to confirm what have been the recommendation and advice that has been given by the DPO. In terms of liaison with the data subject, so it is good to have established a channel of communication so that it is ensured that queries are responded quickly, and if there is a complaint, is also processed in a serious manner and taken into consideration, so that the rights of the data subject are implemented in an effective manner. And also this, of course, needs to be documented and surely included in the record of data subject rights request. In terms of activities with the authorities, so one action when a DPO is appointed is for the DPO to be registered within the ICO or supervisory authority that is concerned, and the DPO needs to have access to the data inventory, so the Article 30 records, to the documentation, and needs to be able to basically be in control and provide the documentation to the authority and be able to respond to the queries that may be raised by the authority. Next slide. So in terms of maintaining and monitoring compliance, so if we want to wrap up, so the DPO needs to really have access to the various departments, the management, and have an overview on the organizational structure of the company, needs to follow up on the implementation of the documentation, the policies and procedures, and need to have access to information related related to the project. So be aware of new project in the operational side to be able to advise in an appropriate manner. You need to be informed, so you need to make necessary effort in order to follow the evolution of the legislation through the guidance and case law, and also needs to have access to the security measures that the company, access to the what is done in terms of security certification, so that it can also advise if additional measures need to be taken in order to reinforce the security of the processing activities of the company in line with the standards and legislation. Next slide. As at GRCI law, so we have access to a range of material, and in general, DPO will need to look at publication from the European Agency for Fundamental Rights that have specific works and studies on data privacy and impact on business. Thomson Reuters and Practical Law. We also are a member of International Association of Privacy Professionals, which is regularly providing information and assessment, so it's very good to have access to that. The Information Commissioner Officer webpage and news, but similar than that, also pages of the European Data Protection Board and other data subject, other supervisory authorities in the European Union. Next slide. So, in summary, the DPO has a pivotal role and is essential in order to coordinating and managing the organization data protection strategy. It has to have legal knowledge, the ability to explain the data protection by design and by default, have information on security, and so also deal and implement the requirement in terms of confidentiality, integrity, and availability, have risk management and risk assessment skill to be able to coordinate and advise on data breach and notification process, support for cybersecurity incident and response project, to support carrying out and interpreted internal audit, and also address the non-conformities that may result from the audit, have familiarity with the sector-specific code of conduct, and also understand standards around compliance, privacy seals, and the ability to cooperate with the supervisory authority. The DPO need to be able to ensure that there is appropriate communication with the board, but as well with the data subject. So it needs to be also a good communicator, have skills in that sector, because it's often very necessary to translate a very complex concept to the data subject. So it really also needs to have good communication skills. Next slide. In terms of appointing a DPO, we can provide a checklist. It is essential first to establish if there is a mandatory requirement to appoint a DPO, and then if the company has that requirement, you need to consider if the DPO can be someone in-house or can be outsourced. And in any case, it's necessary to check the professional skills and qualification of the DPO in order to ensure that can fulfill the role in a competent manner. Next slide. Also, it's necessary for the company to assess the level of independence, ensure that the DPO can fulfill the task and be able to advise and give recommendation independently. And it's good practice to develop a standards procedure with the organization in terms of appointing the DPO and fulfillment of the task. And if a DPO is not required, then it is always good to consider if it is not appropriate to have a DPO that is appointed voluntarily, because in general, as we said, we have the two pillars, the core activities and also the activities that are related to the ongoing activities BAU of the company. So still it's necessary to have someone that can oversee and advise on data privacy. Therefore, it may be wise also to have a DPO, even if it is not mandatory. And the approach that we have seen in the business, and that has been reported also by the EDPB, is that most of the companies tend, even if they do not have a legal requirement, to appoint a DPO, or in any case an expert that can support the company with compliance in data privacy. Next slide. Yeah, we are now at the section where we would like to focus more on the situation of conflict of interest, and I will give then the floor to Natalie that will drive you through that area.
Thank you, everybody, and welcome to the focus on situations of conflict of interest. I'm just trying to take over the slide here, so just give me a minute. I think if I'm In 2023, the European Data Protection Board conducted a coordinated enforcement action looking at the role of the DPO and creating a report. Within this, I wonder if, Loredana, if you can, I don't know if, what's happening with the control of this. Let's just try to get back. Thank you very much. So they conducted a coordinated enforcement action looking at the role and focusing on the role and independence of data protection officers. They published these findings last year in January, and they found they had numerous concerns about conflicts of interest where DPOs held additional roles, especially in areas of IT compliance and legal. They actually found 17,000 of the companies they reviewed not to be compliant in that regard. And the reasons were mainly, of course, that the DPO had not been appointed when it was mandatory in the first place, that not enough training was provided to the DPOs they did have, that those DPOs were not given sufficient resources by the companies, and lastly, of course, and most importantly for me at this moment, the conflict of interest. So when you have a dual role in the company as a DPO and another thing, for example, head of IT, there's really a risk of compromising the ability of people to act independently. And that is a requirement in the GDPR under Article 38(6) of the GDPR. So this highlights the ongoing attention European supervisory authorities are giving the issue of conflicts of interests. So it's very important that you do make sure that if it's mandatory for you to appoint a GDPR, that there aren't conflicts of interest in that role, and if there are an internal DPO, that the conflict doesn't exist. So it's a primary duty of a DPO to ensure that there is impartial oversight, and in order to do that, they need to be independent, objective. You can't mark your own homework. It's important that they're independent and they're free from conflicts and interests, because that's foundational for them to actually provide the services and fulfill their roles and duties effectively. Now, what really happens is conflicts arise if you have a reporting structure wherein DPOs are not able to independently oversee data protection, because they need to be able to operate autonomously and align compliant efforts with legal requirements over business goals. So, for example, if you had your head of IT as your DPO, there could be an issue that they are actually reviewing the security or the security level of the systems, as well as actually deciding on which of those systems to implement, what security systems to implement. It would really be difficult, if not impossible, to be impartial in those circumstances. So why is it so important, you would ask, that a DPO is independent? A DPO's independence and freedom from instruction on DPO tasks is set out in GDPR Article 38.3. Independence ensures that a DPO can provide unbiased oversight and act in the best interests of the data subjects and fulfill the DPO's legal obligations without interference and conflict between organizational goals and the DPO's duties. Because really the DPO serves as a check that the organization is actually processing data properly and in compliance with the DPO and in the interest of data subjects. So I did have someone ask a question. I'm just going to have a quick look, see. Yes, there was an interesting question, exactly that. What are the thoughts of us as far as a scenario where an InfoSec manager or CISO is the same person as a DPO, and what are the pros and cons? I would say that there aren't really, the problem is, as I mentioned earlier, that the CISO is determining perhaps often what the systems and what IT and what the security levels are. So they're really involved with the making decisions about the actual operational management of the security of the data. So it would be very difficult to determine whether there is not a conflict. I can turn to Loredana to give her opinions on this. Loredana?
Yes, it's a complicated situation because the data protection officer shall not be involved in decision-making process or any instance where there must be decision on budget. So the role, the description of the role needs to be taken into consideration, and if there is a risk that there is this interaction where the data protection officer is involved in decision-making activities, this is surely to be avoided as a situation. Basically, there has been a report that has been published last year by the EDPB, where there has been some clarification on conflict of interest and role that of course, the DPO cannot cover, because otherwise it cannot give advice independently. As stated earlier, so the DPO role is to protect, ensure that the business is compliant, but also ensure that the business basically implement in an effective manner the data subject rights. And in some situation, the DPO advice would not be an advice that is in favor of the business goal. So this situation may be one of conflict of interest, in fact.
Thank you very much, Loredana. And it's important to note that other than the EDPP's report, there's also provided national insights from, for example, the Estonian Data Protection Inspectorate's observation that DPOs are sometimes assigned roles in IT, information security, legal and compliance area. And the broad scope of responsibilities in those areas can lead to potential conflicts of interest, as a DPO might be tasked with overseeing activities that are also responsible for executing. The EDP report underscores the importance of maintaining the DPO's independence and avoiding any assignments that could compromise the impartiality of the DPOs. So if you're in a role in IT or in some sort of role that there may be a conflict, it's very important to look at the tasks and duties of the DPO as described by Loredana earlier, and look at the role that you have in the company. And as Loredana said, how much decision-making ability do you have? Also, are you actually self-monitoring in any way? I mean, if you are the one who is responsible for doing data protection impact assessments on new processing systems being used by the IT, you cannot be the one who then has reviews and the DPO who then checks that this is in fact, that the DPI is properly done and that, they are satisfied that the effect on data subjects is such that it's not high risk, or that enough mitigations have been implemented to prevent substantive risk to data subjects. So this issue of self-monitoring is quite important to look at in these circumstances as well, because you've got to remember that the DPO acts as a guardian of data protection compliance, and they advocate at all times data subject rights. So significant conflicts can arise if they hold a role that involves the operational decision making. This independence ensures that a DPO can provide unbiased oversight and always act in the best interest of the data subject. So again, there might be a conflict between organizational goals within the company and the DPO's duties. For example, developing a very exciting new AI system that can assist with your work, or purchasing that system. But if you're in IT and that's part of your role, and you're making a decision to purchase that system or implement that system within your organization, you cannot be the one that actually determines whether it's too risky, or it's not really the DPO's determination, but who advises that it's too risky and determines what the risks are to the actual data subjects. So it's quite a balancing act, and it's very important that you balance your duties. For example, in your specific role, if you're working on IT, because there's several people who have asked questions in relation to IT, and exactly what control you have over marking your own homework, decision making in regards to the organizational processing of data, etc. This is often, I suppose, because if I can add, organizations often prioritize profitability, which that's what you're there for, your commercial organization, efficiency and operational success, and these clash with the DPO's obligation to ensure lawful and fair data processing, or can often clash. So again, a marketing manager, for example, would seek to use personal data for advertising. So while your DPO needs to look at whether that's properly used, it can raise concerns about the lawful processing basis that data is used for. So often when a DPO holds a business critical position, such as head of IT or compliance, they would struggle to audit or report their own decisions. And an IT director, for example, that are acting as a DPO may implement data systems that are subsequently tasked with assessing for compliance, as I said before. So another important issue, and I think Rodona might have, the Spain AEBD, Spain Data Supervisory Authority. I'm having a really bad day with acronyms today, so do excuse me, I seem to be stumbling over them. But in the Spain AEPD 2021 case, the DPO actually reported to senior management directly to the CEO. And in that case, they actually decided that because the DPO reported to senior management without safeguards, the amount of organizational pressure was quite influential on the decisions that DPO made, and that led to a €100,000 fine because there was no protective protective roles between the DPO reporting. So even in that case, they felt that affected the independence. So on top of looking at what your actual tasks are compared to the job of the duties of the DPO, looking at whether you'd be marking your own homework, you'd often have to consider the organizational structure and who you're reporting to within the organization, whether that impacts on the independence that you have. So there's been quite a few cases, as you can see, in regards to conflicts. One of the highest fines that we've got at the moment is the German retailer fine of €525,000, where here the DPO was actually the managing director of subsidiaries, and he was responsible for data processing. The role caused a conflict of interest because he had such strong decision-making powers, but those decision-making powers were obviously related to making sure that the business was doing well, which is the role of, generally a role of someone who is a managing director, and that would clash with the powers or requirements of a DPO in monitoring that all the actions that a company is making aligns with data subjects' interests and the GDPR. Loredana, do you want to make any comments on all of these cases that we have at the moment? There's quite a few here.
Thank you, Natalie. You have covered very well, so nothing to add.
Okay. So here you can also see we mentioned Luxembourg in 2019, €50,000 fine for prioritizing marketing over compliance. We have a Swedish fine. I won't even try to pronounce. I apologize if anybody is very good with their Swedish pronunciation. You're welcome to correct me if I did try, but Forever's Finance Sweden, there was a 10,000 euro fine for DPO self-assessing data breaches. And we have a Belgian DPA 2020, 75,000 euro fine for dual role as compliance officer because that would undermine independence. And of course, we're looking at this situation here, what I've just spoken about the independence being affected by who you're actually reporting to within the organizational structure that the DPO is working in. I think, it's quite interesting note that there is advantages. I'm probably bringing this up a bit early because I know Loredana is going to do a summary at the end, but currently there's been no specific fines or issues related to outsourced data protection officers. So most of these fines are all concerning DPOs that are internal appointments where the conflicts of interest which were conflicts of interest insufficient support that compromise the DPO's independence and effectiveness. So even in cases, for example, with the effectiveness and conflict of interest, there's also, of course, resource, which there needs to be sufficient resource for your DPO. And they need to be supported properly. There can be a conflict as well. Again, another thing to think about is if you were working in an area in finance that determined how much money supported your DPO and the DPO, was holding the purse strings and had pressure in order to not provide sufficient resources, that could even be a conflict as well. So there's quite a few judgments. There is also a 2024 interesting, the most recent, I would say, but that actually comes from, it comes from when there was COVID. So in 2024, so I'm trying to think, the Austrian DPA fined a company. It was only a 5,000 fine, so it wasn't a terribly large fine, but it's an interesting fine because that was a laboratory manager, and he worked for a diagnostic laboratory, and they appointed the laboratory managing director as the DPO during the COVID-19 pandemic. And because the managing director was working in the laboratory, he had such an oversight of data processing operations that created a conflict of interest. So and that's quite a small organization. The laboratory was a very small organization, and that's why the fine was quite small. But even small organizations must ensure DPO independence, according to the Austrian DPA. So the small size of your company does not make it any easier as far as being able to appoint anyone internally as the DPO. You have to consider, how much conflict that has. There's a lot of concerns about impartiality and conflicts if you are, especially in the managing director or in the executive arm or in the IT or any of those areas that really have a strong say in the data security aspects or in managing the company. We see a lot of fines seem to be in that way. So that seems to be quite common. For example, the XFAB case in Dresden in 2023, an individual served as both the chair of a company's work council and as DPO, and the CGEU confirmed that the DPO could hold both roles, but he could not have any decision-making authority. So you'd have to have a look, and he wouldn't be able to make any decisions in his other role as that would affect the data processing. So in the CJE judgments, and as you see in the previous page, I'm just trying to get back to that one. Sorry, I just seem to have some issues with my slides. Is it possible? It's just very slow, so I don't think I have patience. But anyway, so here we see in the CJE judgment case in 2021, DPOs can perform other roles. It's not saying you can't have an internal DPO, but you just have to ensure that there's no conflict. And then, because as well, remember that DPOs, your internal DPOs, are protected against dismissal or penalties when they're doing things or fulfilling duties within their role as a DPO. They can't be punished by the organization for that. But the main thing that came from this judgment was avoiding self-monitoring. So you can't check your own work. I think that's the case in most jobs, really. It's not a good idea to assess your abilities for yourself without an external or another person that's involved. And in the CJE judgment case in 2022, they explored again the relationship between the DPO's monitoring role and their involvement in operational decision making. And in that case, they held that any decision making role over data processing creates an inherent conflict of interest. So that's a thing to think about. If you've got any internal party that has a decision-making role over data processing, that would be an automatic conflict of interest as far as the role of DPO is concerned. So the French Supervisory Authority, and not just the French Supervisory Authority, we also have others, but we're just highlighting the guidance from the French CNIL, saying that DPOs must have a separate reporting structure, no direct operational responsibilities in order to prevent conflicts, because there will be potential conflicts when DPOs are senior managers in IT, HR, or legal departments. The Information Commissions Officer must operate independently, free from conflicts of interest, and they mustn't do anything that compromises impartiality. So I think if I can move over, we've got quite some of the slides that follow up. Also, of course, just emphasize what I've just said. So back to Loredana. Apologies, I've taken a bit of time. So Loredana, thank you for being patient with me, and back to you for the benefits of outsourcing.
Yeah, thank you, Natalie. So benefit of outsourcing the data protection officer. So this is basically in line what we have as guidance and decision in regards to conflict of interest. So outsourcing the DPO would means basically that you will avoid the situation of having to assess the level of independence or conflicting situation if the DPO is undertaking side roles than the DPO itself. So outsourcing to a company or an external individual could help on avoiding that kind of issue in regards to the GDPR. So a company like us that is composed of specialized lawyers that have access to resources and have several year experience would also reassure the fact that the DPO has the right competencies in order to fulfill the role. So access to expertise, and also a company like ours would ensure that you can benefit of a tailored contract that would ensure that they are affordable depending on the size of the company, and for sure will help to basically avoid the risk related to independence and conflict of interest, because basically you have access to proven compliance framework that would help you to avoid fines and penalties. And also, of course, the external DPO, as the in-house DPO, can act as a point of contact with the supervisory authority, and companies that are specialized in the field, they do have basically often contact with the authorities, and therefore are able to liaise with the authorities very easily comparing to in-house DPO. How GRCI solution can help with outsourcing? Basically, we have a solution of data protection officer as a service that would offer the possibility to have access to a team in practice, because you have the main DPO and you have a deputy DPO, the second DPO, that would ensure continuity, which is one of the elements that by having an in-house DPO, company in general struggle. And also we are composed of DPO specialists and legal services, and also we have data subject access access request EU representative services, so we can guarantee access to other services as and when are necessary in an easily manner. We do have templates and established practices and also access to international source, and with our experience it's possible to have a tailored solution to the need of the business based, for example, if at the beginning we undertake a gap analysis, therefore we have an action plan and we can support you in basically undertaking the necessary action to ensure that the level of compliance can be implemented. Then in terms of the conflict of interest and oversight, so we establish a relationship with a contact person in the business, and so we have access to the structure of the company, and we get an understanding of how the company work, and we are able to advise and report to the management so that they are informed and they can receive also information on what are the practices from the supervisory authority. For example, when there has been the announcement in regards to audits for cookies, we could tackle that in advance so that companies have been prepared in order to basically avoid to be under the eye of the supervisory authority. For surely, the main point is that conflict of interest and independence are elements that with an outsourced service doesn't constitute an issue for the company to achieve. Then follow-up slide. So the added value of GRCI law, it's really the holistic approach to compliance that our team has, and the fact that we are not classical law firm, we are not taking into consideration contentious activities, but we do basically support the company to prepare and actually have achieved the compliance to avoid to have disputes. We offer practical and hands-on solutions, and we are able really to support the company in reinforcing the compliance level. Next slide. So here you have a slide where we have a summary of the services that we can offer in complement to the DPO as a service. So you can have a look at that afterwards. And I think we have arrived to the questions. We are quite over the time now. We will gonna follow up with the question we have received. So some are on the conflict of interest, and the CISO can be a data protection officer as well. So I think we have responded that, but basically the conflict of interest situation needs to be assessed on a case by case, and actually it depends on the implication of the DPO. The DPO shall not be having any participation in decision making process or have any responsibility for determining the means or purposes of the data processing activities. So it is about making an assessment and be able to justify that there is an absence of conflict. But if we look at the case law, and specifically to the case that has been decided in Belgium, so basically all the management position, IT, human resources, finance, so generally are at a high risk to be in situation of conflict of interest. So it's really something that needs to be considered carefully, and specific assessment need to be conducted to ensure that the conflict of interest is not existing. There are also some questions in regards to the templates for the data inventory. So here at GRCI Law, we do have the templates that we often use, but from practice, the one that is the most suitable is the one that is available on the ICO website. There is one that is elaborated from CNIL that is very complex, but some companies also use it. But I think that the ICO Article 30 records, it's very well structured, and there is a page related to the processor and one for the controller. So it's one template that I can surely recommend. There are many other questions, so we cannot cover all. We will follow up after the webinar, and we are now arriving to the end. If you have any other questions, also when you will listen to the recording later on, or for any other matter or a service that you are interested on, of course you can reach out, and we will be very happy to help. Thank you very much for your attention, and once again, happy Data Privacy Day.
Thank you. Have a lovely privacy day, and we will get back to you with any questions that we've answered during this webinar.